Welcome again to Salulaw channel. My name is Femi Salu. I'm an attorney. I do practice in Mississippi and Tennessee. And today we'll be looking at our sixth episode, episode 6. I want you to again share or subscribe. And if there's any particular topic that you want us to cover, please feel free to, show us down on the screen and let us know there's a particular topic you want us to cover. Episode 6, what lawyers look for in a medical malpractice case. I get lots of calls on people who feel their doctor have done some wrong thing or the other. They want the lawyers to take action. And this episode will allow you to know whether or not you have a medical malpractice case. I want you to listen to this. Approximately 400,000 medical errors and mistakes are made every year by doctors and hospitals. Let me repeat again. 400,000 medical errors and mistakes are made every year by doctors and hospitals all over the country. Out of these figures, more than 250,000 people in the U.S. die every year from medical errors and negligence. Let me repeat again. 400,000 medical mistakes and errors are made, and out of these 400,000, 250,000 people die every year. Due to no fault of theirs, but due to the fault of doctors and hospitals. The mistakes that were made that caused their death. Right now, the medical malpractice is the third leading cause of death in the United States. That is, the mistakes that are made are the third leading cause of death in the United States. But when you look around, you see that lawyers file only 20,000 lawsuits every year. Let's go back again. 400,000 mistakes are made. 250,000 people die every year from medical mistakes and negligence. And lawyers file lawsuit only in 20,000 cases. Why? And this is what I intend to discuss. The first reason is medical malpractice lawsuit is pretty expensive and time-consuming. Before any medical malpractice lawsuit is filed, it must be accompanied by a certification from an independent doctor that the errors or mistakes are beneath the professional standard. What that means is this. It's not your lawyer that will determine whether there has been medical malpractice. I don't know. You bring a stash of medical records to my office. I don't know anything. I'm going to send it to a doctor. I have a general sense of what I am looking for. But the person that really makes that final decision is going to be an independent doctor. He's the one that will review those medical records and give me a certificate which I will use to file a lawsuit. That certificate will say they have looked at those records. The errors and the mistakes made by your doctor or medical facility or hospital are beneath the professional standard in the industry. That certificate costs a lot. The going rate is between $500 an hour to $1,000 for the doctor to review the medical records and render his opinion. I have seen medical records as thick as my hand. You know how long it's going to take that doctor to finish reviewing it? And is charging you $1,000 an hour to review it? It's pretty expensive upfront. Don't forget, you have not even filed a lawsuit. You have not won your case. And your lawyer is expected to front those expenses upfront. So you better have a good case before that lawyer makes that decision that he wants to take a medical malpractice lawsuit. I want you to know this. Doctors and the insurance company, they fight medical malpractice lawsuit like your pit bull. You know, when a pit bull puts his teeth on something, he doesn't let go. They fight. And most patients or their families do not have the resources to fund a medical malpractice lawsuit. That means litigants rely on lawyers to use their money to fund a medical malpractice lawsuit in what is known as contingency fee basis. That is, we accept those cases as lawyers on the condition that we only get paid if we win. If we lose, all the expenses, all the money that we've expended are gone, and you won't owe us a dime. That is why medical malpractice cases lawyers choose. The second reason is lawyers look for mistakes or errors that resulted in catastrophic injuries or death. What I mean by that is, people call me and say, look, you know what, Mr. Salu, I went to see my doctor today. He gave me a medication and it makes me sleep. I missed going to work. He didn't warn me. Well, what he did was wrong, but it's not a case that I'll be interested in, because I do not see what I consider catastrophic injuries. And I want you to also know this. Catastrophic injuries, the jury is largely suspicious. They are skeptical. They are laymen and women. They are skeptical. They want to see serious injuries before they found the doctor liable. And don't forget again, doctors fight. They do fight. When you see medical malpractice being fought by lawyers for the doctors, some of the lawyers for the doctors, representing the doctors, will almost indirectly threaten the jury and say, look, you know what? If you find Dr. so and so or this hospital liable, they will close. That is an effective blackmail or deterrent that the jury will say, especially in those small towns which has just one hospital, to say, look, you know what, I don't want to find, no matter what has happened, sorry, I can't find that the hospital was liable. I'll give you an example of why we want catastrophic injuries or death. There was a case in the Delta in which a young man was shot in a club. I represented that young man. I think he was 28. Don't worry about why he was shot. That's irrelevant. He walked to the ER of a hospital in the Delta with a gunshot wound. He couldn't see, the doctor was not around, he couldn't see them. They Whether they phoned the doctor or not, we don't know. It took that hospital 20 hours. The young man walked into the hospital around 11, 12 midnight, and throughout the night, no decision was made as to what treatment. He was just there with a gunshot wound. Around almost 20 hours later, that is when the hospital decided, you know what? We are not equipped like a critical trauma center to treat gunshot wounds. Let us take him to Memphis, where the hospitals have critical facilities to treat gunshot wounds. By the time the patient was transported to Memphis, he died in transit. I took that case and when I asked for the opinion of an independent medical doctor who is in Michigan, he said he has never seen such an egregious negligence, an egregious case as this one. The young man just virtually bled to death over indecision of a hospital and its doctor. If medical mistakes happen to a young man or child, and if they are catastrophic, leading to death or serious injuries, as a general rule, lawyers are interested. If it's a young man or a child, the reason is this. Apart from claim for pain and suffering, lawyers can hire experts to project future lost wages or income for the life of this young man or child. If the same thing happened to a 60, 70, or 80-year-old, most lawyers will not take the case. Not because they don't have a good case, but because they have fewer or zero number of years remaining in the litigant's lifetime to project any future loss of income. Again, we are looking at two things. We're looking at recovery for pain and suffering. You're looking at projection for loss of income. This is why lawyers look for either children or young men and women. That is, you should remember that for medical mal. However, I don't want you to give up. If you are elderly and your medical mal was serious, and I've taken that case of a guy who is an elderly man. He went to the hospital, he was admitted, and he was retired. He was in his 60s. He fell, even though there was a fall prevention precaution sign on his bed and on all his medical records. They allow him to fall. He had multiple broken bones. In such cases, we are not going to look at the fact that he's in his 60s. We took the case because that was a case of medical neglect. So I don't want you to see what I am saying as saying that if you are seniors, we won't look at your case. No, we do. What I'm just saying is the priority of most lawyers, the case they jump at in medical malpractice cases is cases that involve children and young men and women. Finally, the question most lawyers often ask is whether the negligence or mistakes could be corrected on the records by the doctor. This is what I mean. I've said before that doctors, not lawyers, determine whether there's negligence. When you suspect negligence has happened, the first thing you must do is to request for the complete medical records from the doctor or facility that you suspect is responsible for the negligence. When you make such a request, most doctors and hospitals have a standard procedure designed by the attorneys to send the request to the doctor for review. I want you to see where I'm trying to get at. Mistakes or negligence made by the doctor or the hospital must be such that it cannot be corrected on their records. For example, if a doctor gave you a medication and failed to warn you not to drive, and you drove and felt drowsy, and you had an accident and you were injured, many may want to sue that doctor for medical malpractice. But before you can sue your doctor for medical malpractice, you must get his medical records that will support your case that he failed to warn you not to drive. Most lawyers will not take such a case. The reason is this. Before that medical records are released to you, lawyers for the doctors will ask him to review his records and correct any mistakes he might make before releasing them to you. By the time you receive those records, you will see in big prints that the doctor warned against taking that medication and driving. That is the end of your case. If the mistakes can be corrected by the doctor, we will not take that case. Any lawyer who understands medical malpractice will not take a case that can be corrected by that doctor, because he knows at the end of the day, those records will be corrected. However, what we look for are mistakes which the doctor cannot correct. For example, I've given you the example of an elderly man who went to the hospital for treatment and he was allowed to, he fell. There's nothing the doctor can do to correct that because the man did not have fracture. He did not have broken bone when he came to the hospital. But how do you now end up treating him for multiple fractures? That was a mistake. That was negligence. That case was settled. Now, if a doctor was supposed to amputate your left foot because of a gangrene, and he mistakenly amputated the healthy right foot, there is no answer. There is no amount of correction he can make of his record. The mistake will be clear and obvious. It is my hope that these three important items will guide you in making a determination, or will provide you with those basic knowledge in making a determination whether there has been medical malpractice that will interest an attorney. Thank you for watching. Subscribe and share. And if there's any topic you want us to cover, please signify below and look forward to the next episode. Thank you for watching Salulaw channel.